Okay, everyone, we are live, and this is Amy Peikoff. This is a Fine Points edition of PodShoot. It's going to be pretty exciting today because we are going to discuss the Supreme Court's ruling in a case overruling the so-called Chevron deference. There's another case as well that we're going to talk about. I'm waiting right now for constitutional scholar, lawyer, and author Bruce Fein to join me. He may have been caught up in the excitement because there's many people who have anticipated this ruling overruling so-called Chevron deference for some time. I'll explain what Chevron deference is so people can share in the excitement if you don't understand it yet. What the court has ruled is that it will no longer grant deference. It will not allow an administrative agency to get away with interpreting its own rules on the grounds that if the rule is vague, you should defer to the interpretation given by the administrative agency itself. And as Bruce and I have talked about, I believe yesterday, this was one of the themes. It's no good if you have an administrative agency.
Okay.
Hi, Bruce. I was just explaining to the audience that we've discussed the point that it is not good if an administrative agency within our government gets the job of both legislating, making the rules, interpreting the rules, adjudicating the rules, applying the punishments, right? All of those roles have been given and, to the administrative agencies. And up until today, our courts have deferred to administrative agencies in their interpretation of their own rules. Is that correct, Bruce?
Yes, I think, but the court's decision didn't quite address as broad of the defects that you've been able to enumerate, Amy. It simply said that no longer is the administrative agency entitled to just interpret its own statute and say these are our own powers. You can obviously see a conflict of interest. Could you imagine telling the president, why don't you decide what powers you have under the Constitution? We will defer to you. We won't decide as judges what the Constitution means, but you get to decide. Well, we know where that would lead, right?
Right, exactly.
And so what the court in this instance said was that unlike the case that has prevailed for the last more than 40 years, stemming from a case called Chevron in 1984, that the courts will independently decide what powers the agency enjoys. And the agencies won't have the ability to interpret their own statutes and say it means X rather than Y, which obviously is going to be an invitation to expand the regulatory state. But aside from that, it's really up to Congress whether to expand the regulatory state. If Congress decides, the court didn't say it can't, but then you got to vote. You've got to get consensus in the House and the Senate,
Right.
435 in the House. As we discussed yesterday in the Senate, you have to go through the deliberative process. The president has a qualified veto. And then they can repeal this if the people don't like it. They can walk into their members' offices and complain. Unlike the executive branch is far more shielded from public scrutiny and feedback than the Congress is. I mean, here in Washington, I can walk up literally in 5 minutes and walk into a senator's office and say, here's something I'm protesting, right? Now, it doesn't mean that that they have to do what I ask, but I feel that I have an impact. They have to answer me. And the executive branch, try to get into the Department of Justice, It's like going through a screening to get into CIA. You can't get there. They have so much screening, we can't visit with them. You can't even call people on the telephone because you have a switchboard and with 5,000 extensions. So the key goes back again to this idea that when you're insisting on process, you're not saying that it has to be used one way or another, but you're trying to make sure that there's an accountability. That's a deliberative process that's built in and it can be checked and changed. And the general idea of process by assigning power to the legislative branch is to say we want there to be debate and consensus, because every time the government acts, it encroaches on liberty. Now, sometimes that's essential. We want to encroach on the liberty to commit murder. We want to encroach on the liberty to commit robbery, right? But that just means you need a consensus, and there's no difficulty in getting consensus. We ought to outlaw murder. Well, just go ahead and do it, and Congress does. We have laws like that. But in other areas where the trade-off between liberty and any possible harm by impairing the opportunities for others to fulfill their ambitions is much more opaque or obscure. And there you want a debate. If you get, they call it gridlock. Well, gridlock is separation of powers at work. Gridlock is saying you
Yes.
haven't got the consensus yet. So that means you need to go back and try to draft a better plan. And if you can't, maybe the optimal solution is to do nothing. That's
Yes.
what the legislators just don't get, that, because in their vision of what their job is, they always think, how can I campaign in the next election? Because I crave being reelected. And I can't campaign on nothing being done. It's hard, right? Or it's more difficult to explain because you have to have brains. You have to have a philosophy. This is why you should be thankful I didn't pass these laws that could have curbed your liberties. But, they can't get into that realm of thinking. They're just thinking, I sponsored this bill, I sponsored that bill, I sponsored whatever bill. And so they think, no, we can't just say we did nothing. We got to show we did something. Um, and
I mean, it would be nice if they would campaign on, I prevented this horrible law from being passed. I prevented that horrible law from being passed, et cetera, et cetera. I mean, why not look at those as positive contributions that they're making?
well, they could, but
They don't.
this is the game that's up there, Amy, that's generally unknown. That the rules and the voting is calculated to enable everybody to vote the way they think their constituent wants them, but knowing the result's not going to change. So, for example, a Republican could say to a Republican, okay, you can vote against the bill because your vote isn't needed. We don't really care. So you can go back to your constituents and say, see, the Republicans are against it,
Yeah,
but
no, it's
they know it's not going to pass anyway, right? And
exactly,
it works on the other
exactly.
side. So that's what the big game is. Oh, it looks like we put up a big fight. But don't worry, if their vote was needed, they say, hey, no more. You got to vote for us on this occasion. But in a very substantial number of cases, the vote isn't needed. Say, go ahead. You have a free vote in this case because we don't need it, and then it means you get reelected, even though nothing changes, and you just can bellyache. But you're part of the game.
Right,
And that's
right.
why that tactic that you say just causes more frustration in the public. Why is it that if you keep voting against this, why the laws keep getting passed? So a handful of people, they'll vote against the spending bills or whatever. But how come the budget keeps getting big every single year? It never diminishes. It's just a
Right.
matter of what the
So
rate of growth is.
let's focus on our little bit of good news here today. I mean, I think it's a lot of good news.
Yeah.
So again, the case is Loper Bright Enterprises versus Raimondo, Secretary of Commerce, et cetera. And this case, can you tell us a little bit about the particulars of this case, Bruce?
Well, here it is. It's just for they would like to know if you want to have reading. It's only 103 pages long, right?
Only 103 today. Okay.
Yeah.
Well, actually, there's three. There's a third opinion that I just saw, by the way. We had talked earlier about the city of Grants Pass versus Johnson. And then they've also dropped one, Fisher versus United States. Which one is that, Bruce?
Oh, that's one of the Trump cases. So I think
Ooh.
our audience, yeah,
So
because
did they just drop that on us in the last minute then?
yes,
Okay.
that's for
Okay. Yeah.
sure.
Fisher just got dropped as well. So we may need you to look at this on the fly. Why don't I explain to people the extent to which I understand City of Grants Pass versus Johnson? This is a case involving the City of Grants Pass, which had a homeless problem. And like so many cities in the West in particular, there is, and they, people experiencing homelessness is the, I guess, preferred way to speak about the individuals involved. But the city of Grants Pass, in addition to other measures, did have or does have a criminal statute on the books prohibiting encampments in the city. And they, exercise prosecutorial discretion in actually applying this criminal statute to the people experiencing homelessness. But occasionally, if you have encampments that are particularly obtrusive or dangerous, etc., they will apply it, and they will encourage the people in the encampments to seek out different shelter opportunities and etc. And the question before the court was whether applying the particular criminal punishments in the case. In this case, there were fines. There was a ban.
Take a look on the court and see if I need.
There was. I'm going to go ahead and mute Bruce just for a second because he's
Yeah.
talking.
So they did. Yeah, Fisher. I'm trying to download right now the
the opinion. Yeah, go ahead. I'm just going to continue to explain the grants pass situation.
Okay, great.
Okay. So the particular criminal punishments in the grants pass statute were initially a fine. There was something like a ban from being in the city for a certain period of time. And then there was up to a 30-day jail term if the person was a repeat offender. And, again, as the cities describe it, a criminal statute like this and the punishments that they would impose are just one of the many tools that they would use to try to deal with the problem of, as they say, people experiencing homelessness. So, again, the question is, are these punishments cruel and unusual punishments in violation of the Eighth Amendment to the Constitution? That was the challenge. And you can see, just by thinking about it in that way, or just, hearing the question presented that way, that really the issue is not that these are cruel punishments, right? A fine is not a cruel punishment. A ban from being able to be in a particular area for a certain period of time is not. Again, if you're guilty of a crime there, a 30-day jail term is not a cruel and unusual punishment. And so all the court held in this case was that it was not a cruel and unusual punishment within the meaning of the Eighth Amendment. And, in effect, what they're saying is that it is not an appropriate challenge to a criminal statute like this to say that it imposes cruel and unusual punishments, that the Eighth Amendment was not meant to tell cities, in this case, what they can or cannot criminalize. It is only meant, the Eighth Amendment, to prohibit certain types of punishments considered to be cruel and unusual, no longer favored. And so this particular tool for challenging a criminalization of encampments, in this case, that tool is removed. You cannot challenge on these grounds anymore. It is not cruel and unusual punishment within the meaning of the Eighth Amendment. And the question that came up, Bruce, earlier when we were talking about this was whether, in effect, it is, actually criminalizing encampment like this, creating homeless encampments like this, simply by the court's ruling. Do you believe that that's the case, that the court, in ruling today that these were not cruel and unusual punishments, has, endorsed criminalizing?
Well, the court's opinion doesn't criminalize anything. It can't.
Yeah.
Only a legislative branch can define a crime. The court just said it's permissible if a municipality wishes to make encampments on public places criminal. Now,
Right.
Typically, the criminal arm is used not to incarcerate, but to encourage the homeless to accept mental health care or to use homeless shelters. A very, very large percentage, as high as 70 to 75% of the homeless, turn aside the opportunity to live in a shelter.
In some cities, reason. Yeah, I was reading that, right.
It's a huge percentage. And so I think it's accepted that in a very, very large percentage, again, about that same level, are drug addicts or mentally impaired. So they're tragic cases for sure. I don't think we should be contemptuous of them. But the fact is that these camps sometimes create public health hazards. They are places where drug use and sales can occur. So they're just not innocuous. Say, well, what does it matter? It's nighttime. They're there. So they have some public harm associated with them. I don't want to exaggerate it, but it clearly is there. Uh, I don't know whether there is any so-called magic bullet to solve this issue. But
Yeah.
the courts didn't say, that no, that we're saying it's criminal to be homeless. It says it's a very difficult issue, and if a city wants to experiment with making public camping, and it's not just cities, then if you want to go to Yosemite or Yellowstone, you can't just go out there camping with a sleeping bag anywhere you want. So the federal government has these same kind of limits to protect the public from inconvenience, to possible drug paraphernalia, and even disease at some particular point. So
Right.
that's the gist of what they said. Now, I think it would be obvious for a viewer here to ask, well, how did he even get to this kind of argument? Because it seems to most people think common sense. You can't have a constitutional right to just sleep on public park. It goes back to a case in 1962 called Robinson versus California, where the court held that to just make drug addiction, the status of being addicted to drugs, a crime, was unconstitutional under the Eighth Amendment. And basically, the decision today overruled that case, said
Okay.
reasoning is wrong. They followed it with another case called Powell versus Texas, in which the issue was, can you make public drunkenness a crime? And they said, yeah, because public drunkenness is an activity, because you're acting in public and you're inebriated. But it
Ah,
didn't overrule Robinson. So you had these two conflicting opinions out there. And let me make this observation. It's kind of more general, Amy, about the Supreme Court, and I've written it elsewhere, having read all their opinions, that the court regularly issues opinions that are contradictory in rationale, but not in the narrowest holding sense. And so you can read majority and dissenting opinions and concurrence. They all are persuasive based upon you can cite precedents in your favor, you can cite canons of construction. But there's so many contradictions out there that you can really just choose whichever ones you want to use to come out to your particular result. It's not as though the authors are insincere. It's just that the law, I consider, is so intellectually flabby that that gives you total room. It's like open field running. You just choose what you want to do, because the court does not overrule a case just because the reasoning was inconsistent with something else. It leaves it there. It doesn't overrule at the drop of a hat, although it has this term: overruled Chevron, overruled Robinson today. Today, two overrulings.
wow.
But this is not. I mean, during the changeover from the earlier conservative court to the Roosevelt court, it was overruling cases like 10 pins. 5, 10 opinions
Yes.
overruled. Every term. So, and then we're witnessing something like this here after the Dobbs case overruling Roe v. Wade and Planned
Right.
Parenthood. So it doesn't happen all the time.
I've
But
I've got a question on the Dobbs later, but I
yeah,
think what people really want to hear is one of the other two cases. People really probably want to hear about Fisher, right? What
yeah,
is
okay.
Fisher? Explain Fisher.
Okay, Fisher is the case concerning interpreting the Sarbanes-Oxley Act that was enacted in the aftermath of the Enron scandal, if people remember that. The fraud that was committed by Enron, bribing and their accounting practices were terrible to show profits when they were losing money. Anyway, and there was a lot of shredding of information, a lot of prosecutions. Arthur Andersen, a big accounting firm, went out of business because they were prosecuted. And so Congress enacted a new law that made it a crime to obstruct a federal proceeding through
Mm,
shredding documents, um, uh, things of that sort. And the issue, but the term obstructing a federal proceeding is more generically is the prohibition. Um, Obstruct a federal proceeding. And the issue raised in Fisher was by a defendant, a January 6th defendant, who was charged, among other things, was obstructing the congressional proceeding to count presidential electoral votes in attacking the Capitol on January 6th. Um, and his argument was that's not whatever else it was. It could be trespass. If you destroyed federal property, that could be criminal. I don't believe this was the only crime he was charged with, but it's not obstructing a federal proceeding. There are no documents there. And Sarbanes-Oxley was stated it's designed to prevent corrupting, impairing, falsifying documents. And the only arguable documents that were at play in counting the electoral votes are the documents that were handed to Mr. Pence. Well, this state has counted electoral votes for XYZ.
Right.
But that wasn't, those documents were not impaired. They were not defaced. They were not falsified. So the court again, the lineup is kind of instructive here. It wasn't the usual 6-3 lineup. Amy Barrett voted against the majority and said this was within Sarbanes-Oxley, that is obstructing a federal proceeding without impairing a document. And surprisingly, and I was at the oral argument, that Jackson, she voted in favor with the majority. So it was a divided court, for sure. A very divided court. So what does that mean? So as a practical,
okay, and ruled what? So they ruled essentially that this was not within the Sarbanes-Oxley.
Yes, that the storming of the Capitol and the effort with the goal of obstructing the counting of the electoral votes was not within Sarbanes-Oxley.
So they could be charged whatever other convictions.
They could be charged with trespass, and
but
they were.
Not this. And again, as we talked about yesterday, you don't know exactly how many defendants this would affect, because chances are, with respect to many, if not all of them, there were multiple charges brought against them. But to the extent that this charge imposed any significant extra punishment on them, then this would overrule that, right? They would be free.
Correct.
Yeah.
Mm-hmm.
Okay.
That is correct. And there may be some, but we know, if we're just asking about politically, we know to a certainty that probably Donald Trump now is waving this as showing the corrupt Justice Department, right? So that's for sure. Okay. So just trying to think of relevance to our audience there. I'm not saying that I believe that their decision was not open and shut by any means. It was kind of pioneering. But in the lower courts, there was only one judge in the lower courts that accepted that narrower interpretation. But they're lower courts. Okay, the Supreme Court has the final say. I believe that you've got to accept what they did. But it wasn't a case where it was loony and everybody looked at it and said, this is crazy. Okay, this is kind of a novel area. On the other hand, you have to say this too, in defense of Trump and the January 6th people. And this, I feel strongly, that if you're pioneering an area that's kind of gray, you ought to kind of resist civil punishments or something, sanctions, damages, that's one thing. But I don't think the criminal law is not drop a nuclear bomb in an area that's very gray. And this certainly was a gray area, if you will. So that's where we are on the Fisher case. So that means we have the United States, Trump versus United, the immunity case is left.
Now, but so who are the justices again who voted with the majority in Fisher? You said Ketanji Jackson, right? Who else?
So it was Clarence Thomas, Kavanaugh, Roberts. Roberts wrote the opinion. Gorsuch,
but not Alito either.
No, Alito was there too. Right now I don't. It was maybe it was Alito, Gorsuch, Jackson.
Okay. Let me see if I can scan through it and find it myself.
Roberts for sure, yeah.
Because this seemed to have been dropped just before we went live, right? This was
you're right. It just came, very, very late in the game.
I'll be scanning. I've got it up on the website, so I'll go ahead and scan through it. But the thing I was going to say was Jackson, right?
Yeah.
from what I understand, she's somewhat of an originalist. Is that correct? Or
As
somebody has.
well, I don't know. Well, she's certainly on the left-hand side.
Yeah,
I mean,
okay, so here it is. Roberts wrote the opinion, and we have Thomas, Alito, Gorsuch, Kavanaugh, and Jackson.
yeah. See,
One,
and
two,
what
three,
are
four,
yeah,
five.
so
That's six, actually. That's six.
but the surprising thing is Amy Barrett's vote,
Right, right.
because
Yeah.
she typically is associated
But so
more.
she concurred. She concurred. So it'd be interesting to take a look at her concurrence and see
Yeah,
what her rationale is. So you've
yeah,
got the dissent, just Sotomayor and Kagan. Those are the only two
yeah,
dissenters.
7-2.
Okay. So we have a
So anyway,
concurrence with Barrett.
I think I misunderstood. I
Yeah.
apologize. I was too fast. I thought that Amy Coney Barrett was with the dissent. She was
No, no,
yesterday.
no.
No.
Concurrence,
Okay,
concurrence.
so it's seven
So,
to two. Okay, so this, I think that then I have to retract my idea that this case in any way foreshadowed a different lineup with regard to the Trump immunity. I don't think
okay.
this is a hint one way or the other. I mean, in some sense,
Okay.
they're different cases for sure. Fisher is not Trump. And the charge against Trump now in January 6th is now confined to one charge of trying to defraud the United States by preventing the peaceful transfer of presidential power by obstructing the counting of electoral votes. So one of the counts against Trump will now be eliminated.
Is gone, right. And so it was good for them to release this one before the more broad immunity for for the
Well,
president. Yeah.
obviously it's going to have
Yeah.
vastly more significance. Yes.
Exactly,
Yeah.
exactly. Okay. But yeah, so I'm going to be interested. Both Jackson and Barrett filed concurrences, and I would like to see the rationales that they have with this. Okay, so anything else that we need to talk about on this, except for I mean, we know some of the practical political implications, as you said, that Trump and other people, who are supporting him are going to say that this meant the Justice Department was corrupt, et cetera, and bringing these
Yeah.
charges.
Well,
I
I
mean,
mean,
you could think about the toll on those who were convicted, and again, to the extent that this particular charge made a material difference in what happened to people, it's a lot of stress and maybe time in prison and all sorts of horrible things that happen as a result of these charges being brought.
well,
Yes.
listen, that's certainly true, and I do will not want to diminish that,
Yeah.
Amy. But that happens, unfortunately. Take what about the Central Park Five that Trump said should get the death penalty?
Mhm.
They're wrongly convicted, spent decades, in prison, and that's not necessarily, a huge aberration. People oftentimes are wrongly convicted, and I certainly don't justify that. But that's the nature of the criminal justice system. You're dealing with human beings, and even with the safeguards of proof beyond a reasonable doubt, the law sometimes gets it wrong, and it's a tragedy for the victims. But it wasn't like these are the only ones who have ever been improperly imprisoned. I wish it were. I mean, I don't want it to be partisan by that means. Um, but this is a feature of the criminal justice system, and why I think in some respects it's flawed. For just give one example, where the court has held that if you're a prosecutor, you can never ever be sued, no matter how malicious your prosecution was, for damages, called Imbler versus Packman. People
Mhm.
understand, well, we need to rein in the prosecutors. Well, change the law. Why? And they interpreted a federal statute. It wasn't something that's given by the Constitution. They don't
Right.
change the law. Now, it may well be, Amy, I don't know, that this decision will prompt Congress to reconsider amending Sarbanes Oxley and make it clear, but maybe not. Who knows? Um, but that's their job to write, especially criminal area. You should be clear. The law needs to warn before it strikes.
Right. Yep. Definitely does. Definitely does. So this opinion, and then the next, of course, I mean, would you say that the Chevron deference overrule is more important in the grand scheme of things? Yes.
Yes, for sure, because its long term impact, I think, will be uh, much more pronounced. The
Okay. So
Chevron
what?
case.
So why don't we move to this one then? We've got Loper Bright Enterprises versus Raimondo, and what was the underlying situation in this case?
Well, it was a regulation of the of fisheries administration, regulating catches and things like that, and whether the Commerce Department was properly interpreting the statute. Commerce Department kind of regulates fishing, so you don't get fish extinct because of over um, catching. Um, but the principle is way beyond the facts of the case. Um, and the principle was, and the lower court said, because the U.S. Supreme Court, Amy, has said we're the only ones who can overrule a precedent. No matter how much you think we're likely to overrule it, it's us only. So don't don't think you can overrule our precedent. And so the lower courts gave deference to the Commerce Department, and the Supreme Court said no. The courts need to independently interpret statutes to see whether or not the interpretation of the agencies is the correct one or not. It's called de novo review, not deference, which is basically means unless they're on crack cocaine and did something wacko, whatever the agency says will be affirmed by the courts. That's a little exaggerated, but not a whole lot in terms of how the Chevron doctrine panned out. But I think the Chevron doctrine clearly it's inconsistent with the letter of it's certainly the spirit, if not the letter, of separation of powers, as you point out. Going back to the most famous case we all learn about in law school, Marbury and Madison, it's the duty of the judicial department to say what the law is, not the executive agency, right?
Right.
And
Yeah, and
so the
I
Chevron,
misspoke earlier, though. I realized I misspoke because this is not a case in which the administrative agency made a rule and it was vague, and then it said you have to accept our interpretation of it. This is a case in which the legislature, the Congress, made a rule granting certain authority by statute to the administrative agency. It was arguably vague. And so the administrative agency perhaps took more power than it was authorized to have under the statute and said, you have to defer to us in grabbing this power because we're allowed to interpret the statute when it's vague, right? So Congress did, do its part of the job here in laying out, in a statute what the authority of the administrative agency was. It's just that the administrative agency had been grabbing more power whenever it could, arguably under the statute. And for, was it decades? You said since 1984, there's been no meaningful check on that sort of power grab, right?
that's correct. I think I might, Amy, describe it a little bit differently. That is, Congress purposely, in order to get a consensus, leaves the statutes opaque. Okay,
Right.
we don't know what
Yes.
it means because they don't want to accept accountability. They want to blame everything bad that happened. Don't blame it on us. See what the agency did? They're out of control, right? So that's why, in my judgment, when you're at that level of opacity, which is what enables the agency to say, well, this is what we think it means because you've left it open.
Right.
Will act in the
Right.
public interest. You decide whether it's a national emergency. They won't define national emergency. Is gun violence a natural emergency? Is hot weather a national emergency?
Right.
Is disease a natural emergency? I mean, you can say whatever you want it to mean because Congress never defines what it is. And so, and that is, I think, a deficiency. Now, I think the court needs to go another step. And the court should go the step in saying, if Congress has enacted a statute that's very vague, let me give you an example that could be understood, but wouldn't necessarily fanciful down the road. For example, a statute says, the Internal Revenue Service shall promulgate an internal revenue law. Okay, that's it. The court, in my judgment, when you're at that level of generality, say you've enacted nothing. We are not going to accept this is law. Law has to satisfy a certain level of granularity, of articulateness that enables people to know what it is. Otherwise, you're just handing off the legislative function to judges or to the IRS. You can't do that. There's a reason it says all legislative power in Article 1, Section 1 shall be entrusted to the Congress of the United States. And it says all legislative power, which means they should exercise it. You can't give it away. They take, for example, think of this as an analogy. Amy. Suppose the Supreme Court decided they issue a rule saying, in cases that we think are really hard and politically controversial, we're going to let the Senate Judiciary Committee decide the case, and you can go argue it there. We'll delegate our adjudicatory power to the Senate. I mean, you'd say, wait, they can't do
And
that,
not
right?
just the Senate, but one committee, right?
Yeah, one committee. Say, wait a minute. The whole purpose of having Article 3 is because institutionally we want people who serve for life and are independent to make the decision, who are not politicians. And all of that purpose is defeated when you hand the decision making to the Senate Judiciary Committee, or if it said the President of the United States will decide this. Because the framers were very, very alert to the institutional inclinations for branches to do one thing or another. And for example, they said one of the reasons why James Madison supported, the Bill of Rights. He said the judicial branch they'll be guardians of our liberties and be very eager, to detect abuses by the legislative or executive when they overreach on our rights. Because they understood they're not running for re-election. They don't have to bow to the majoritarian
Right.
views or whims. And so they understood the institutional importance in allocating power. And that's just so out of whack because Congress doesn't want to do anything these days. They take all the orders from the executive branch, and if it's vague, okay, give it to agencies. Courts can decide. It's at the outset, and this is where you would be able to see very, very pronounced differences in the early Congresses and today. In the very early Congresses, there were very, very substantial debates over the constitutionality of what they were doing. I remember the first Congress, 1789, they were deciding whether can we restrict the president's ability to fire the Secretary of State or his cabinet members or not. Does he have the right to remove or not to remove? So the Congress believed that it had a responsibility to make its own assessment of constitutionality before they passed a statute. Today, the attitude is court can decide, not up to us. We'll hand it off. That's not right. And part of the reason why it's not right, Amy, is as we were discussing the other day, because the issue of standing is oftentimes so much of a hurdle, it's never going to be able to get into court.
Right.
They aren't going to decide.
Right.
So if you don't make a serious effort, the constitutional issue will just be open-ended, will be nothing.
I mean, all of them take an oath, do they not? They all take an oath. And the oath is that they are going to, in, performing their duties, keep in mind that they have a duty to uphold the Constitution as part of this. And, as you say, maybe a lot of them today will say, oh, all the big debates about the constitutionality of what we're doing have already been had or something. But I don't think that's right. I think at every moment where there's even a bit of a question, they should be revisiting that, at least in their minds, if not in explicit debate, right?
Yes. I mean, it's in Article 6 of the Constitution requires an oath. Article 2, in fact, defines the words in the presidential oath. So it wasn't an afterthought. It's integral to the Constitution. And you're absolutely right, Amy. To say that these issues have been decided, we're seeing overrulings. If it's decided, why are we getting the best and the brightest on the court dividing 5-4, 6-3? They're obviously not been decided. So you need to do your homework, get in there and
they were decided within a particular context of knowledge that existed whenever that decision was made, right? And in the decades or centuries or whatever that have passed since that time, more things have happened. And so there's more things, that anybody with a mind to history can go back and look at and see for additional evidence that point towards maybe reconsidering the decision, right?
Yeah, I mean, Amy, and I know this is your favorite doctrine, and maybe the audience is getting tired of this. That's exactly what's happened to third-party doctrine.
Exactly. No.
Because way before the digital age, so they had no idea of the encroachments that were coming. So why are we living in a horse and buggy age? And
to flesh that out a little. So the third-party doctrine was expanded without much fanfare or justification in the 1970s, and it was expanded in cases involving our banks or our telephone companies. And at that time, as you say, it's way before the digital age. People didn't have computers in their homes and et cetera. And nobody at that point could have conceived of the amount of information uh, on a daily basis that we share with third parties just in going about our daily lives and availing ourselves of all sorts of wonderful conveniences that make our lives better and richer. And so now, if you say, well, whenever you share information with a third party, the government can obtain it without a warrant, they can track you 24/7, 365, pretty much all of your activities and thoughts and everything else. If they can grab all that information, which they do, we have to assume they do. I was going to say, normally when I have a webcam in front of me, I routinely make an obscene gesture to it, for the purpose of, just telling the NSA, reminding them that what they're doing at this exact moment is unconstitutional. I will refrain from making that gesture right now out of the courtesy for our audience. But I do this regularly to any of my devices just to remind them. I know they're watching and they know that what they're doing is blatantly unconstitutional. But yeah, if the court could have foreseen in the 1970s the extent to which we would be sharing all of this with third parties today, it might have given them pause. And I think that alone is reason to have a serious reconsideration of the doctrine. But as you say, it's almost impossible. And Snowden's talked about this as well. And it's why he made his revelations, right? It's very hard to get standing to challenge all of this government overreach, all of this warrantless surveillance that's going on. It's a huge problem.
Yeah. The government says, okay, if we're not using it against you in a criminal prosecution, why do you care? Just we got a dossier on you because they leak it out, and so you can't get loans, you can't get jobs, you can't get enrolled in a university or whatever. How would
It's
you ever
only
even put this
money. It's only
information
money,
in?
right? Yeah.
Yeah, yeah. I mean, and listen, I want to go back to your observation, and that is there was a justice, Louis Brandeis, in 1928. This is when wiretapping, first appeared on the scene, largely going after those who were bootleggers, alcohol. And he wrote in his dissenting opinion called Olmsted versus U.S. He's some wise guy. He said, we have no clue what's going to happen in the future. And to say because the words of the Fourth Amendment say persons, houses, papers, and effects, it doesn't have conversations, to say it doesn't apply, it's going to be, don't worry, it's going to come back and haunt us, right? He said there's going to be changes. Of course, anybody who's been around and understands the history and evolution of technology knows it's been evolving for centuries. It always does, because
Sure.
it's a cumulative process. Einstein said I could see so far because I stood on the shoulders of my predecessors, including Isaac Newton. So he warned, he saw what was going to happen. And
Okay.
but no, he
I
was
know. The reason I'm smiling though, Bruce, right, is because Brandeis is the one who wrote that article in 1890,
about
right? Was
privacy.
right. And that article laid privacy on a pragmatist foundation that has been our undoing ever since. And when we have our big kind of smackdown privacy oriented show, we keep talking about it. Eventually, we're going to have the whole show on this. I'll explain to you the link between pragmatism and privacy and how this pragmatic approach, whereas at first it seemed like it was going to protect our privacy more, in practice, it undermined our rights to property and contract, which are the true foundations for how we create states of privacy and maintain them for ourselves.
Well,
So I
remember,
say that privacy is not legalized until we enforce our property and contract rights in such a way that we are able once again to protect states of privacy for ourselves.
mm-hmm. Well, I'm not, won't quibble. Remember, Brandeis at that stage, it was decades before he was appointed to the court. And moreover, he was writing about the right of privacy to protect your own name, from invasion being basically hijacked for somebody else, to go utilize to sell a commercial product. He's not talking about the Fourth Amendment. These are private things that are happening in what he's addressing in his right to privacy with and it was a law review article. It's not a judicial opinion. The Fourth Amendment is quite different. Whatever you want to say about the, and I'm not saying that the private sector has a serious concern about invading your privacy, but compared to the government,
No,
it's like
exactly. I mean,
it's
yeah.
like comparing, a giant oak to an acorn. The government has all these staggering resources out there, and you don't they and plus all the secrecy, you can't get access to any of it, you don't know. And that's what he was writing against the Fourth Amendment in government activity. The law
Yes.
review
Yeah.
article was just relating, basically, you're stealing people's name, you're going into their homes and exposing them to ridicule or whatever. It's a different thing. Anyway, I feel compelled to defend Louis Brandeis. He was not he was very
Well,
far.
no, we can talk some more about that. But yeah, there's, he was the attorney for the situation and all of those
Yeah, yeah.
things that he did. Um, okay, so we have today the court being very clear and distinguishing between something that is a cruel and unusual punishment versus a challenge to criminalizing a particular behavior itself, being very principled in drawing that distinction, not necessarily saying anything one way or the other about whether a city can criminalize mere homelessness or being in an encampment. It's, really, if you're going to bring an Eighth Amendment challenge, it's going to be focused on whether the particular punishments imposed are cruel and unusual in the originally meant sense, right? That's the
That's
first
correct.
case.
Yeah. So no longer, I basically, so now they rejected the idea that it was cruel and unusual to just make drug addiction a crime itself, irrespective of what the punishment was. You just
Right,
couldn't make it a crime under Robinson. That's now gone. That's a
right,
museum piece. Okay. Now they focus on behavior, and then what they say. The cities are not sentencing the homeless people under their rules, because the case came out of the U.S. Court of Appeals for the Ninth Circuit. It wasn't a nationwide ruling, so other cities were still utilizing these measures. But I don't know if any city is sentencing the homeless to 30 years in prison or anything like that. They understand it's a very serious problem, and I sympathize with them. But
yeah,
I sympathize with cities that also say, well, we have to have some civilized limits on camping in the sidewalks and whatever. You have disease, you have drugs, and all sorts of other things. It's just a very, very challenging problem to deal with. The law really isn't all that helpful. It's
right,
far deeper than the law of mental health, drug addiction, and things like that, which we don't have easy answers to, because we've been dealing with mental health problems and drug addiction, Amy, as long as I can remember in Washington. The war on drugs 50, 60 years ago. We're dealing with a problem that's endemic to human nature. We struggle with best we can with it. And I think what the court did is struck the right balances. It's not for the judges aren't going to resolve this. The municipalities got to go back and they can at least try experiment how they can. Doesn't mean it's got to be fixed in one way, and see what the result is.
right, right. And then in the Loper Bright case, we have an overruling of the so-called Chevron deference, such that if an administrative agency tries to interpret a statute granting it authority, the courts can now challenge that
They do
interpretation.
their job. It's just the
Finally,
exercise duty
yes.
to say it's the go back to Marbury and Madison, Chief Justice John Marshall. It is emphatically the duty of the judicial branch, to say what the law is, and that's in the decision here. In Chevron said, well, no, really, it's emphatically the duty of the agency to decide what the law is. Well, why is that doesn't make any sense. And let me go back, if I can, Amy, for just a moment to pause. And why did they come up with this doctrine? They came up with the doctrine because they said, well, the agencies are kind of expert in the subject matter in which they deal, because obviously they have an ongoing preoccupation with the environment or with fisheries or with a whole host of things, drugs or whatever. And they said, therefore, since they're expert in their area, why don't we? They're going to be better able to understand, what the law means than we are, because they're experts. That may well be true in some sense, but the analysis is way incomplete. There are also people and officials who like power, right? And that
Sorry, I
means
lost your audio
their
for one
expertise
sec.
is going to be maybe compromised by their desire. Hey, I'm in this agency. I want power. I'm going to fix the world. I'm a genius. I'm smarter than the other people. These are the technocrats, the progressives that think they know better than everybody else. So their interpretation is going to be swayed because there's something, they have a conflict of interest. What would they do? Interpret a statute to narrow their power? Whoever yields power, you can take power from people. The number of people who voluntarily surrender power, you can count on your hands with fingers left over. It doesn't happen. And so it's not getting rid of Chevron. It's not because the judges are expert in everything, but at least they use
Hmm.
customary standards of
I lost
statutory
your audio
interpretation and
entirely, and I don't know
construction,
why.
and they don't have a conflict of interest coming out one way or the other because they don't get any power by interpreting it one way or the other. Their judicial power remains the same. That's why Chevron is so mischievous, in my judgment, that they only asked one half of the question. Do you have expertise? Yeah. But you also have a craving to try to misuse the expertise to get power. That's why we don't trust you. I mean, you want to ask, does the intelligence community have expertise? They sure do. But I don't trust them to tell the truth. They may have expertise, but they could tell you the opposite of what they know because it's all secret. So this
Okay.
idea, this idea of expertise uber alles, it just doesn't work. You got to understand what human nature is. If the smartest people in the world can do really stupid things. Was Napoleon really, really smart as a general? Yeah. He marches to Moscow in the winter and kills 2 million French soldiers because he's compromised. He was intoxicated with power. And the judges just didn't understand that phenomenon.
No, it's definitely a logical fallacy to completely defer to experts. So during COVID, this really got me, of course, because everyone was saying, oh, experts and experts. But in order for you to take an expert's advice without committing a fallacy of appeal to authority, say, you need to keep your mind active and to do everything that you can to question the expert, have him or her explain themselves, right? And you check against, of course, logical inconsistencies, everything else that you know. And yeah, you don't have the expertise that they do. And so at a certain point, after you've done everything that you can to see whether what they say makes sense, you say, okay, well, I am going to act this way or the other, knowing that I don't necessarily have the knowledge of somebody who went to medical school and had 20 years of a practice and et cetera. But you make the best judgment that you can and act on it and know that you're not right. But the extent to which people will say, oh, we just have to defer, and they can be supposedly confident in their decisions that they make according to just deferring to an expert and not being critical about it. I found that breathtaking in the last few years.
Well, that's true, Amy. And also, at least with regard to COVID, what at least should have given some hesitation in believing in the so-called experts is the expert didn't all agree. You
Right.
had you had people who were trained at the best universities saying no, the masks
Mhm.
don't work. No, vaccine's not going to work. No, social distancing is useless. The immune system is going to work, but those with comorbidities do need some special protection because they have more vulnerability to dying
Right.
than young people do. And
Yep.
they were experts trained, and they weren't getting paid, with by drug money. I mean drug company money, pharmaceutical companies to say any of this stuff. They just looked that this is not something that is likely to be truthful, and compare that diversity of expert opinion, as I brought up before, like the salt polio vaccine. I never heard anybody say, "Oh, salt polio vaccine not going to work." Everyone looked at it. It works. Okay, then that makes my confidence level rise very high. Even 100% consensus could still get it wrong, but
Sure.
diminishes the likelihood. But when
Yeah.
experts themselves are all disagreeing, you could say, you know what? Maybe they really don't know what they're talking about. I
Well,
need
and
to be
plus just logic, right? So it's early days, so you can't tell what the long-term effects of a particular vaccine are going to be. And so bringing up reasonable questions about such things when there's a new technology being used, I think should be welcomed, right?
yeah,
Not shunned the way that it was. So let's go again to the Fisher case, okay?
Mhm.
And I've got a question here from someone who was watching us. It says the court just seemingly ruled that invading Congress to stop an official proceeding is not obstruction of justice. It is trespass, but not obstruction. So then he says, it seems there is no crime of obstructing an official act. So long as people enter Congress, enter and stop it from certification of a presidential election and do so without causing property damage, they will be charged only with trespassing. Is that right?
I think under the current, I think that's an accurate description given the law where it is now. But remember, the court is interpreting Sarbanes-Oxley, which is not enshrined in granite. You could amend the law and change it. But right now, interpreting Sarbanes-Oxley, yeah, if you're not engaged in violence, not destroying property, but you're just there without any lawful authority, you're trespassing on government grounds, that would be the only ground that you can be prosecuted.
Okay. Okay. Makes sense. So those are the rulings. We've only got a couple minutes left, but given that we had this very interesting debate last night, and by the way, I'm going to tell everybody we're going to be back Monday because we're still waiting for the big presidential immunity case to
Yeah.
be decided. And as we said, it was good that Fisher was, released before that time because it also applies to prosecutions against former President Trump. But last night, did you have anything that you wanted to say about the debate? Did you watch that fiasco?
Well, number one is I hope there are no Supreme Court vacancies the next 4 years. I wouldn't trust either of these to make an appointment. I mean, really, Biden I thought was dreadful. I
Mhm.
can't believe he could survive another 4 years. He can't even complete a sentence,
Exactly.
and
What
you have
about the next 7 months? What about the next 7 months, right?
yeah. Well, I don't think there's going to be a vacancy in the next 7 months either. I mean, really, I don't. If you look right now, Amy, at the ages of the justices, their health, none of them are clear candidates to leave the court in the next 4 years, for sure. I think the one who's most senior is Clarence Thomas. Um, but I thought Biden was dreadful. He couldn't complete a sentence. He didn't know how to articulate what his policies were. He just looked very weak and listless, almost anemic. Um, at Trump, virtually everything he said was a misrepresentation of facts. But to my mind, as a citizen, I was most disturbed that again, when he was asked, "Will you accept the outcome of the 2024 election?" he refused to
Right.
say yes. He basically said, "If I think it was fair, I will." I think they should have followed up and said, "You mean you're going to have another January 6th if you lose?" And forced, he might have evaded that anyway. Um, so
He was pretty good at evading the questions he didn't want to answer, huh?
yeah, he didn't. Yeah, and I thought the moderators were deficient in saying, calling the audience, "You didn't answer the question, Mr. Trump." Well, the audience just should know that. We'll go to the next one because you can't force somebody to answer questions they don't want to.
No.
They don't have any coercion, but they just sort of highlight that he's dodging what the question was. He should be able to answer that. But again, going back to Biden, what I think makes it especially alarming is that we know that there must have been meticulous preparation, Mr. Biden, before the debate.
Mm-hmm.
Everyone knew on the Democrat side this could be a big moment, and his performance still was way more than suboptimal. Yeah, could you imagine getting a grade in a debate society for that? I don't
Well,
think
and this is what I was reminded of. Some of the speeches that he gave in answer to the questions, he was essentially reciting things that obviously he had learned or, memorized, right? And I didn't get the sense that it was actual cognition that was going on corresponding to the words that were coming out of his mouth. That was my impression. And there were a couple times that he was delivering essentially the same speech, which was, the United States is the best country in the world and
yeah,
people would trade with me or us or whatever, right? And that didn't seem genuine to me. I had one question, one substantive legal question about something that he said when they were talking about Roe versus Wade, and Trump was patting himself on the back for returning it to the states as if he did it all by himself. Of course, he appointed justices who I think, made probably a correct ruling in Dobbs based on, the Constitution. I've listened to Akil Amar analyze the substantive legal issues there. And I was persuaded by him, by the way, about jobs. But the thing that Biden said in response to Trump patting himself on the back was that he promised to bring Roe versus Wade back. That cannot be done, right, Bruce? You cannot bring Roe versus Wade back, not in the courts anyway, right?
Well, the courts couldn't do that. You would have to have, if he's president, a federal statute that would try to enact this nationwide, whose constitutionality would be dubious. I said, what in the Constitution gives Congress authority over abortion? There's nowhere there. Nothing. It's a blank slate. So where is your authority to do that? And that's why you've had some Republicans say we need to have a 15-week or 16-week period after which you can't have abortion. Where's your authority? It doesn't even come close. And also because the court, in the Affordable Care Act case, cut back the kind of limitless scope of the Commerce Clause. It says you have to be regulating commerce. When you're regulating abortion, that's not regulating commerce. You're doing it because you think it's a moral issue. And that means then you're outside the Commerce Clause territory. And if you're outside of that, I don't know where the Congress would get authority to reenact Roe versus Wade anyway. So he's clearly wrong on that score. I think, if I can just make this observation, Amy, I certainly would agree with the understanding that the original Roe v. Wade decision, Planned Parenthood and Casey, were wrongly decided. I don't think they just made this right to privacy up out of the penumbras and emanations of the Bill of Rights.
Yes.
When I was going to school, penumbras and emanations I learned about in astronomy. I never learned about penumbras and emanations in
it's
US
such
right?
pragmatism. It's complete legal pragmatism. Yes, go on.
So, but then there becomes the next question. I think I'm all four square on that's true. The next question is, but should they have overruled? Because some cases are wrong, and they figure Congress can amend the Constitution, right? They amended the Constitution to overcome Dred Scott. They amended the Constitution to overcome a ruling saying that a federal income tax was unconstitutional, right? So they amended the Constitution to say that women have a right to the franchise without any discrimination. Now, amending the Constitution is more difficult, to be sure, than just a statute, but there are ways to correct Supreme Court errors. And as a prudential matter, I thought it was questionable whether at this stage you're going to overrule the case. And they went beyond just saying you could have 15 weeks changing the age, the gestational age at which you could have an abortion. It did not seem to me that the mischief, if you will, of the decision kind of infecting other areas of the law was sufficiently great that you'd say, okay, we got it wrong. Congress, you can amend it like you've amended other instances. If you think we got it wrong, and then we'll just move forward. So that's the only, and that is, overruling question is clearly prudential. There's nothing in the Constitution that gives a court guidelines as to when you overrule a precedent, right? You just kind of go with it as you see it. And there is a utility and predictability in the law. And I think that unlike the expectation, I think, of the majority by Alito that, okay, we're just going to hand this issue back to the people, right? The people will decide. The courts aren't going to be involved, but that hasn't been the case. The courts are deciding all the time abortion issues.
Right.
That's yesterday on Idaho,
right,
and in Texas with regard to the drug induced,
the availability of the abortion pill, right?
So it's not going away. You're not kind of getting the judiciary out. Your hope is that we just clean our hands like Pontius Pilate. Now we're out of it. It'll just be with the legislative branch. Good luck. It didn't happen that way. On the other hand, I will say this, that I do believe it has a healthy and beneficial effect in awakening and getting the people more engaged, and through referendum, they're addressing this issue. And the people then are debating it like they should. I think in some sense that Roe versus Wade and Planned Parenthood and Casey just kind of dulled those who think that there ought to be more weight on a woman's right to choose. And they just felt, okay, we got the courts behind us. We can be inert citizens anywhere. And that's not a healthy sign. So it had at least a useful effort. And I think that the country is now more galvanized, in addressing the issue. And even Mr. Trump has said he's not in favor of a federal statute regulating abortion. Uh,
Exactly.
so,
So that
I
was
mean,
the one positive you could say for him last night, right?
yeah, he got that. I don't know whether he did it for the right reason, but yeah, he got the Constitution right, even if it was unwitting.
Right, right. No. And anyway, yeah, I'm going to later today have something that we planned long ago. And I don't know if I would have planned it had I known that you and I were going to be talking every day, but I'm going to be talking with Mark Pellegrino, who is an actor. I don't know if you're familiar with him. He was in Lost and Supernatural and all kinds of other good things. And he's also a political commentator. And then Matt Kibbe of Free the People. We're going to do a post debate discussion later today on BitChute. So I'm not going to say too much more about it, but did you want to say anything more about the debate before I let you go today, Bruce?
Well,
And I'm going to
listen,
talk to you again Monday. Yeah.
all I can say, Amy, and I don't want to be kind of uh, quipping, is read the Lincoln Douglas debates. Listen to what happened last night and tell me, have we gone up or down in the quality of the debate, the wisdom, the character, the understanding of law from the Lincoln Douglas debates in 1858 till today?
Right.
I think it won't take you very long to see how far our political culture has decayed. That's all I can say. Because I listen, to be candid, I don't belong to the Republican or Democrat parties. I think both parties are dreadful. Um, but I believe in institutions, I believe in process, and I believe in process that's informed by people who are educated. It's not that everybody gets a chance to vote. I'm not in favor of saying you can't vote if I don't think you pass an IQ test. This is just something that ought to be, in my judgment, a norm. It ought to be enforced by social custom, ostracism, if you will. Because if you're not engaged as a citizen, we're going to lose it all. That's how Athens lost its democracy, as Gibbon recounted in his Decline and Fall of Rome. So let's not go that way.
Agreed. Okay. Well, with that, we'll draw a line and I'll be speaking with you at 11 Eastern on Monday. I assume the big ruling is coming down then.
Yeah. Okay. Thanks, Amy.
Thank
Thanks,
you. Thanks
thanks the
everybody for
audience.
tuning in.
Okay, I always want to thank the audience. You're the ones we're here for. So any
Definitely. Yeah.
advice you
And
give,
leave any
we're here.
questions in the comments below, wherever you're watching this. Thank you.